14, Arbitration Appeal 7 of 2026.
Appeal dismiss.
Well, in better logic, we could file the application for condonation of delay, substitution, and setting aside abatement yesterday. Those are not on record, my lord. Kindly, I prefer taking up those applications along with this, my lord. Next week, my lord.
Pardon?
Well, here the sole respondent, he died. We got the information. Accordingly, we have filed 3 applications for setting aside abatement, substitution, and condonation of delay. We could file the applications yesterday. So these are not on record. Lordship may kindly take up the applications along with this appeal next week, my lord.
On?
Next week, my lord. After
Next week.
After week, my lord.
Okay. On the pairing made by Mr. Dinat, learned counsel for the applicant, having not been opposed by Mr. Das, learned counsel for the respondent opposite party, the matter stands adjourned to be listed in the next week.
Lordship.
So do we fix a date?
My lord may give a date, my lord.
Correct.
Lordship.
17, June.
70, my lord.
Thank you.
Lordship.
Number 2.
Is on next another court. Kindly take this matter.
Who is just in here?
As that.
Yes, that's
Application.
okay. After some time.
Items for hearing. Number 4.
Your lordship asked me to produce the original bit. I lost my person. I produced. And type copy I also given.
Pardon?
Translation copy I also furnished. Now, my lord.
Okay.
Before my London friend starts, I have a preliminary objection.
Pardon?
I have a preliminary objection. Because in this case, respondent number 10, Sagar Ali Mondal, he died. He died during the pregnancy of the suit. And his heirs were not substituted. And the suit has been tried against the third person. The apparent charges filed a petition under order 1 rule 10, and that petition was registered as 2213 I civil lawsuit and the 2213 of 2021. Wherein they filed an application under order 1 rule 10. That petition was rejected by the Honorable Court. Therefore, without implementing the heirs of respondent number 10, the suit is a nullity because if the decree is passed, it is an unexecutable decree. Because principal relief is against the defendant number 10 also. For that reason.
Order is there, but so far as defendant number 10 is concerned, the suit was filed against the dead person. He was already dead.
Yes.
He was made a party wrongly. So his name has been deleted. So no harm has been, suppose the defendant number 10 suit as a whole suit will not be abated. Maybe against the defendant number 10, if they come, it is another matter. They have not come, they have not any objection in there. In the main suit and main title suit, my lord. So there, if the suit has been filed before, after date of the respondent number 10, so it is wrongly their name mentioned. So their name has been wrongly deleted here. So there is no harm, my lord. There is order. I has been passed, my lord. Suppose out of 10, one person died. Their legal has not been implemented. So whole suit will not be evident, my lord. Whole suit will not be evident. There is a decision, several decisions of this honorable court. So maybe their legal heirs have the rights. Their share is they will get. It is not a matter. They will may get it. But as a whole, other defendants concerned who are contested the case, suit is maintainable. There is no bar.
Your Lordship, pending order passed by this court on
Okay. I
24/6/2022. IA 221.
Because that application filed, because since the defendant number died before filing of the suit, that is why that petition has been filed here. It is not for substitution as for order 22, my lord. So it is filed under order 1 to aid as a party.
no, if the person concerned died before institution of the suit,
Yes.
Yes.
then
There is nothing.
no, it is you who have who had instituted the suit.
No, they are the plaintiff.
Okay.
They
I am
are
the-
plaintiff.
I am the plaintiff.
Okay.
The defendant, respondent number 10 died during the pendency of the suit.
Pendency or before?
No, before filing of the suit.
And his heirs were not brought on record. Therefore, a suit against the dead man is a nullity, and no executive decree could be passed.
Executable degree may not be passed against the respondent number 10, his legal here. But others, so far others is concerned, suit will go.
No, it is.
So accordingly, suit has been proceeded, my lord. They file a petition there. I check the record. They file a petition there. That has also not been considered. That is also not been considered because no order was passed on that, my lord. They file a petition there for substitute the legal heirs of the respondent number 10, but no order has been passed. I send the record, my lord. No order has been passed. So, my lord, so far as the respondent number 10 is concerned, he 10 was died before filing of the suit. So his legal heir, if any objection, they may come file a suit or it is up to them, my lord. And respondent 10, 9, 10 all are related. They know the fact. They know the facts, my lord. All are related persons. They should not also disclose before the trial court, my lord. That so and so person has been died. Because later on, after filing of the suit, they come to learn that the person, respondent 10 was died before filing of the suit, my lord. So he is not necessary parties at all, my lord. It may, so I file a petition here to implement to aid party the legal heirs of the respondent 10. That was not considered by this honorable court. So it will go against other respondent. It is not a whole someone died, their legal has not been brought on record, and the suit will go. No, my lord. There is a decision, several decisions are there. This honorable court.
Can you produce those decisions?
My lord.
Can you produce those decisions?
That now not present, but I have this. Similar matter I haven't argued, my lord, and this honorable court allowed this petition. Similar nature.
Okay, then let it be on Thursday.
Yes, ma'am. I will tell you.
Heard, Mr. They have made learned counsel for the appellant and
Has the-
Mr. S.C. Sharma, learned senior counsel assisted by Mr. Vardas,
তাতে hearing আছে না?
learned counsel for the respondent.
এগুলো করি।
Lays the matter on Thursday, so it's to enable Mr. Ahmed, learned counsel for the appellant, to produce relevant decision of the Honorable Supreme Court in respect of respondent number 10.
10.
Respondent number 10, who suffered demise before institution of the title suit number. What was the number of the title?
My lord.
Title suit number?
Taxation.
Title suit number
Title sheet number.
58 of
58 of
2013. 30. List accordingly
My lord, it may be called at 2, my lord,
on that day. Okay, at 2 p.m.
Thursday. Thursday at 2 p.m.
Number 5.
Original to the
Yes.
On the last day, my friend's part has complete,
Okay,
and my part is there. But she, first of all, my friend is basically the raises questions of the loss of amenities and attendance charges. The London Tribunal has awarded 2 lakhs.
I did nothing. Nothing is in
It means 90% disability. That is not in question. That is admitted. 90% disability. In fact, she is 100% physical disability. Although the medical opinion is 90% disability, but she is 100% because she is not in a position to move without wheelchair and assistance. Till date.
No, 100%. No.
Well, 100% is physical disability.
100%
Is physical disability, functional disability.
functional
My
disability.
lord. Although the medical, as per medical board law says that 90% disability, but this is the present position also. Incident was taken place in the year 2008, 21/4/2008, and in the year 2016, she filed a claim petition lawsuit. She appeared before the tribunal, but she was not possible to cross-examine. That's why that has been prosecuted. Just one paragraph of the judgment lawsuit is paragraph 8. Paragraph 8. Page 11.
Paragraph number
8.
of the judgment.
Judgment lawsuit. Page 11.
Yes.
In course of trial, though the claimant had her evidence or affidavit and the appears before the court for cross-examination, but she was not cross-examined as she was not in a position to face cross-examination as per order dated 9/4/2016. And her evidence is not considered. The claimants had examined other 4 witnesses and the contesting party duly cross-examined them. The contesting parties, opposite parties have not adduced any evidence. So she was not in a position to cross-examine. Because that is also after
No, why commission was not appointed to examine her?
she was appeared before the court, not in a position to say.
Oh, not in a position to
Yes,
speak.
not in a position to say. It's totally
Okay.
disable. Brain injury, chest, hand, leg, etc. Multiple injury. And another paragraph was paragraph 21 of the judgment that has clearly been there.
PW2, Mala, he was also a victim, in that case, actually. And she also filed a appeal, sorry, the MSc test that has been awarded and that has been satisfied by by the insurance company. And she herself was the victim. Mala, PW2. PW2 in her evidence stated that after the accident, the injured was treated at Lower Assam Hospital, Noida, whereupon she was shifted to GNRC Hospital, Gauhati. The discharge certificate of GNRC Hospital reflects that the injured was admitted to Lower Assam, Noida on 21/4/2008. That is the date of incident. And was discharged on 27/4/2008. On careful perusal of the process and bills proved by the claimant, it reveals that an amount of rupees so-and-so, say rupees so-and-so, was expended during treatment of the injury. Except the claimant is entitled to this amount as medical expenses for the injury sustained by her. The claimant's mother, PW2, in her evidence stated that due to the accident, the claimant became 90% permanent disabled. Regarding disability, claimant examined PW3 Dr. Shomit Chaudhary, one of the member of medical board, who deposed that on so-and-so, he examined Suma Kundu, he is the victim in this case, and issued disability certificate, exhibit 226, and they assess that her disability as 90%, which is not curable and permanently disabled. He also stated that her disability was post-traumatic quadripresis and she cannot move without wheelchair. He proved his identity card as exhibit 228. Claimant also examined PW4 Military of Orja. The employer social welfare officer was here to report that as per doctor's report, the district social welfare officer used to issue identity card of disabled person. He stated that medical board assessed disability of Sumakundu as 90%. He proved the identity card issued in favor of Sumakundu as exhibit 226. During cross, he admitted that there is no mention in exhibit 226 as to how the disability was caused to the claimant. As per evidence of PW4, Vidut Kanti also the claimant has 90% disability. Exhibit 226 shows that claimant cannot walk without existence of escort. The discharge summary reflects that he sustained traumatic brain injury experienced bilateral equidus deformity. She cannot move without wheelchair and not yet in a position to give deposition. Considering the injury sustained by her, this court consider her disability as 90% and as such, claimant is entitled to pecuniary damages for loss of earning capacity to the extent of due to income sustained in the accident besides medical expenses. Now taking to question of income, claimant stated that his income is concerned, he was the female attendant in the laboratory. That was a laboratory authority was has proved the income of 5,000 per month. That has perhaps might be as the question. So I am not traveling on that part of thing. And so far, Lordship, PW3 doctor's examination. If your Lordship permit, then I can proceed.
No, not necessary. No, the contention of the appellant was that the assessment, the procedure adopted by the learned tribunal in assessing the functional disability of the victim
Yes.
is not in accordance with the decision of Honorable Supreme Court in the case of Rajkumar versus Ajay Kumar.
Yes.
That was the contention of the counsel for the appellant.
To theoretical Lordship, I am going to rely that the deposition of the doctors. What was the nature of the injury? Whether it is functional disability, amounts to functional disability of 90%.
No. 100%. You tell me whether the tribunal has adopted the procedure prescribed in that decision.
I have not come through that way.
Then that is the point.
Lordship,
Come prepared.
Yep.
You go through the decision.
Yeah, Lordship, I want to go through that.
When?
2 p.m.
Today.
Today.
আগতে শেষ হ'ব।
I will not take time, Lordship. Only, best Lordship 10 minutes.
Okay, all right. 2 p.m.
Item number 7. Sorry, item number 6. Affirmative.
May I please your question?
Yes.
May I draw my attention to the will, page number 52. Page number 52.
You are for the respondent.
I am for the respondent, my lord.
Okay. Your part is completed.
My lord, I have to submit some judgment, my lord.
You have submitted.
No, my lord, today I submit.
Okay, let him complete then.
Yes.
Okay.
May I draw kind attention to the page number 52, will. Is
Yes.
this last will and testament of Munin Chandra Burwa, son of Gokul Chandra Burwa, by religion Hindu, resident of Hatigu, Sariali, Nilambur, Gauhati, is made on this 11/5/2009 at Gauhati in sound mind and sound health without any influence or corruption for anybody. By this will, Munin Chandra Burwa, execution of the will, bequeathes movable and removable properties in the following manner. So, yes, my lord, there is nothing in the will, nothing on record that the testator, Munin Chandra Burwa, had any special love and affection to his nephew. There is nothing in the will.
Is
There
it
is-
necessary to mention the same in the will?
Lesser love and affection. There
No,
any
is it
special-
necessary to?
Then the respondent has filed petition under order 1/2/10/2. And on that ground, he has been implicated as a party to this case after 11 years. That is, originally the petitioner tried to get it ordered by ex parte. But the respondent has gotten information in the year of 2020, that is 19/11/20. And she has filed objection, that is page number 57.
Page number
57, she has filed objection.
57.
57, my lord.
Yes.
I have reviewed the content of the objection. The objection filed by the opposite party, that is number 4, Mrinalini Burwa, against the applicant under section 220 and 281 of the Indian Succession Act. The application filed by the petitioner under section 280 and 281 of the Indian Succession Act for granting probate in favor of the petitioner. Petitioner, the for property estate by the deceased Munin Chandra Burwa, resident of Hatigor, Sariali, Post Office Juro, PS, District Kamrup, by the LS will, there is 11/5 is 2009. It is not maintained will long. With regard to the statement made in petition, the answering party beg to state that no comment, and the petitioner is put to strict court. That with regard to this vital point is this, para number 6.
Hmm.
That with regard to the statement made in paragraph 6, 7, 8, and 9 of their application, that is answering opposite party beg to state that her husband, that Munin Chandra Burwa, never executed his will on 11/5/2009 to the petitioner. Further state that during the April to 2009, her husband Munin Chandra Burwa was seriously fallen ill, and he was not physically and mentally sound to executing will in favor of the petitioner. including the petitioner and the petitioner taking the advantage of the illness without the knowledge of the answering opposite party, has secretly obtained some signatures in the blank paper and had typed it and converted it to the last will of the testament Munin Chandra Burua. The presence of the in presence of the own sister of Ranjana Sharma and her husband. This will has been executed by PW2, who is the brother-in-law of the petitioner, and PW3, who is the own sister of the petitioner. Yes. This answering opposite beg to state that petitioner and opposite state, namely Ranjana Sharma and Satyabrata Sharma, had a conspiracy, made a conspiracy to deprive the property of the petitioner, of the petitioner. 8. This answering opposite part beg to state that Munin Chandra Burua was shown as executor of the LS will, and he was the director of the accounts and a law graduate. It is not convincing that same person will make him appoint a petitioner, namely Pradeep Kumar Pachadi as executor of the will, as mentioned in page 5 of the Annex B of the application. It is presumed that the cunning petitioner typed those papers with his signature and secretly obtained during the lifetime of the Munin Chandra Burua had manufactured it, the last will and testament of the Munin Chandra Burua. So, here in this case, it is therefore respectfully prayed that on Honorable Gauhati please to reject the application for probate. So, after considering the objection petition and their petition, that is probate petition, the learned court, the trial court has framed the following issues. That is, yes. This prayer number 24, my lord. Whether Munin Chandra Burua legally executed the will dated 11/5/2009 as the last will in favor of the plaintiff. 2. Whether the will was acquired by fraud. Whether the will was duly attested by the attesting list. Whether the plaintiff is entitled to relief claim, additional issue. Whether the executor can make a will under the provision of the Indian Substitution Act. And whether at the time of execution of the will, Munin Chandra Burua was sound and disposing state of mind. So, this issue has been framed. And accordingly, the plaintiff appellant has adduced 4 evidence. That is, one is propounder of the will, that is Pradeep Kumar Bhattacharya. PW2 is the brother-in-law of the plaintiff. PW3 is the own sister of the plaintiff, and another is Murun Burma. So when they have been examined, I am reading out that is, they have first, I draw your kind attention to the cross-examination of the Pradeep Kumar Bhattacharya. First, 89 case. I was not present, 89 case, my lord. I was not present at the time of execution of the will. My lord.
Which
I was
part?
not
At
present.
which part?
89 case, my lord.
89, that's all right, but
89 of cross-examination.
no, that's all right.
Got it, my lord.
In the last part or in
The
the,
party which 1, 2, 3, 4, 5 lines, my lord.
yes,
I was not present at the time of execution of the will.
yes.
My lord, last part.
Mm.
I do not know the place. I don't know, I'm reading out this. Munish Chandra Burua, I'm reading out the prosecution total. I don't know whether an executor can make a will under the provision of the Indian Succession Act. It is a fact that Munish Chandra Burua was suffering from Parkinson and neurodegenerative disease. Here it is come, that is Section 59 of the Evidence Act. Person making a will, he must be sound mind and capable of making a will. Person 59 of the Evidence Act, Indian Succession Act. So if he is suffering from Parkinson's disease and neurodegenerative disease, that is, he is not a sound mind. So here, my lord, I do not know the effect of Parkinson in neurodegenerative disease. I do not know who drafted the will. I have not read the draft of the will. I do not know as who has instructed to prepare the will. I do not know as what the executor, that is executor, has understood the content of the will. Whether this executor has understood the content of the will, he does not know. And accepted the same. I do not know whether the attesting witness of the will verify the probate application or not. I do not know as to whether the attesting witness are independent witness. My lord. That is one thing. I have not submitted any document. I have not submitted any document to show that Munish Chandra Burua was physically and mentally fit at the time of execution of the will. I don't know whether he was mentally fit, sound at the time of execution of the will. I do not know as to whether the attesting witness made any statement to the effect that executor to the signature of the in their presence. I was not present at the time of execution of the will.
Okay. So your contention is that at the time of
Execution of the will.
execution of the will, the person concerned was suffering from Parkinson disease.
Yes, my lord.
So he was not in a state of sound mind
Yes,
to put his signature in the will.
well,
That is your contention.
yes. If he is suffering from Parkinson's disease,
Mm.
as per horizontal internal medicines, what is the effect of Parkinson's disease? I am reading out the contents of the Parkinson's disease. So, it is a fact that the state of what is not there in the will.
Mm.
But in my evidence affidavit, I have mentioned the word testament. I have been shown. I have shown the property schedule, but schedule is not there. He has shown the schedule, but schedule is not there. So it is a fact that in the year 2009, Munish Chandra was suffering from last night, but he has nicely admitted that Munish Chandra Burua was suffering from Parkinson in neurodegenerative disease. So if a person is suffering from Parkinson in neurodegenerative disease, so section 59.
No, is there, Mr. Talukdar, is
Yes.
there any document, medical document to support that contention?
No document has been supported, no document has been furnished by the petitioner appellant in support of the claim. That they have specific.
No, I am asking you,
Yes, madam.
it is your contention that the person concerned was suffering from Parkinson disease. Do you have any medical document to support your contention?
It is the burden of the proponder to prove.
Hmm.
It is not my burden.
No,
He
that's
himself-
all right. It is your contention that he was suffering from Parkinson disease. So burden of proof lies upon you. You have to establish that he was suffering from Parkinson
I
disease.
have not stated, they have clearly stated. I have not stated, appellant has clearly stated that he
Okay.
was, I have not said anything. Appellant has nicely admitted, clearly stated that Mr. Pradip Kumar Bhattaji was suffering from Parkinson disease. I have not stated anything. That's why they are unable to produce any document relating to the sound mind of this case. So it is the main burden is on the proponder. Oh, yes. It is a fact, Munition was suffering from Parkinson's disease.
My lord, the next paragraph is clear, my lord. In the cross example,
My lord, 88.
in page 89, my lord, second paragraph.
Hmm.
It is not a fact that in the year 2009, Munin Chandra Borua was suffering from ailments, my lord.
Hmm.
Because will was made in the year 2009.
Hmm.
The witness specifically stated that at the time of execution of the will,
Hmm.
the testator was not suffering from ailment, my lord.
Hmm.
Maybe on the later stage, he was suffering from Parkinson, my lord. But at the time of making the will in 2009, he was not
Okay,
suffering from
okay.
ailment.
No document, nothing in short, as per horizontal internal medicines. When, at what age the Parkinson's disease start? The mean age of the Parkinson's disease from 60 years. Now in the will, they have not mentioned any age. Within they have not mentioned any age. As per horizontal internal medicines, the mean age of onset of Parkinson's disease is about 60 years. It is not, it is a. Oh, yes. It will help. Mean age of onset of PD is second paragraph, first paragraph. Oh. Oh, that was for English.
In fact, my lord, the respondent refused to give any evidence in the trial court, my lord. He refused to give any evidence, my lord. This evidence from the order dated 7/6/2023, the trial court, my lord. They refused to give any evidence, my lord.
Refuse to give?
Any evidence, my lord.
Okay.
It does not mean the respondent will admit everything because during pendency of the case, my respondent has expired. Then come to his nice wish. So it does not mean that I have everything. It is the burden of the plaintiff. It is the burden of the proponent to prove. The petitioner did not prove the will. Petitioner did not prove that the will was signed by the testator with his own free will after knowing its content. No document, nothing of the sort. Petitioner has failed to prove. Petitioner has failed to prove that the will was signed by the testator with his own free will after knowing its content. I am citing the ruling also. So again, this again another witness that the petitioner to. Since there is yes. Page 33, my lord. My lord, there is no other document to show.
Yes.
My lord,
Hmm.
page 33. 1, 2, 3, 4, 5, 6, 7, 8 lines.
Hmm.
There is no other document to show that Mulin Chandra Bora executed the will. There is no other document to show. Mulin Chandra Bora executed the will, having read the content and understand the disposition. made in the will. My lord,
Mm,
at the time of execution of the will,
mm,
Munin Chandra Bura is near about 80 years. At the time of the execution of the will, Munin Chandra Bura was 80 years. In the will, there is no specific mention. Then Munin Bura signed in their presence. There is no statement. And they have attested the same. They have attested the same. He has put signature in the will in their presence. But he does not consider not taking the signature of the Munin Chandra Bura, wife of Minani Bura, was present with him in his house is wrong. That means the PWK stated that Munin Chandra Bura has gone to my house along with his wife. When the PWC also present, but no signature in the will as a witness has been taken. It is a suspicious case, suspicious circumstances. It is purely suspicious. Why signature of Munin Chandra Bura was not taken? It is purely a suspicious case. Again, my lord, on going to the will, he does not find any word testator in the will. Although there is no testator in the will, in his presence, in his evidence on the benefit, he uses the word testator. In paragraph 567. That's why Munin Chandra Bura made the will, but he does not know. Munin Chandra Bura made this will. He does not know. Was instructed to prepare the will. He does not know. Was instructed to prepare the will in favor of the plaintiff. There is a certificate to show in paragraph 34, my lord. Paragraph 34. Page 34. Page 34.
mm.
My lord, there is no certificate to show that Munin Chandra Bura was physically and mentally fit, mentally sound to execute the will. Except him, that is, except PW2, who is the brother-in-law of the proponder, plaintiff, and his wife, who is the sister, own sister of the plaintiff. There is no other witness to the will. It is purely suspicious case. That is brother-in-law and sister. Had said
No,
the conspiracy to make the
Mr.
will.
Talukdar, is it mandatory to produce such a certificate at the time of execution of the will that he was physically fit and mentally sound to execute the will?
As per provision, they are bound to produce the certificate.
As per provision.
Provision.
Which provision?
Section 59 says.
Section
59.
59.
Succession Act
Okay.
says. My lord, section 59 says, person capable of making will. Every person with sound mind, not being a manner may dispose of his properties. Soundness of the mind.
No, where is the requirement of production of any such certificate?
Then I am ruling. May I draw your kind attention to the judgment AIR 2020 Supreme Court 2641. May I draw your attention?
Who is decision?
Pardon, my lord.
Citation to correct.
Which one?
Gupita Kunwar versus Mehta, 19 May 2020. I am given the citation.
Yes.
Page 18, my lord. Page 18. Page 18, my lord. Paragraph 46. Paragraph 56, my lord. There is no evidence coming forth to explain the suspicious circumstances of excluding the respondent number 3.
Paragraph number?
Pardon, my lord.
Paragraph number?
Paragraph 46.
46.
Yes. Page number 18, my lord. I have a flag mark.
This is Kavita Kanwar.
Yes. No, no, it's Kavita Karas. Gupta, yes. Page 46. Page 46, my lord. Yes, noted above, there is no evidence that he has understood the content of the will. He has understood the content of the will before signing it. In this background, exclusion of the respondent is also grave suspicion.
Paragraph number?
Pardon?
Paragraph number?
46. 46, my lord.
No, in this decision, there is no paragraph number 46.
Here's number 18.
Citation, please.
Citation to good.
Citation, please mention it again.
Kavita Kanwar. এটা হয়।
Year 2020 S 2814.
2614. 2020.
No, Mr. Sodore, you see,
Yes.
in this decision, there is only paragraph number 36 or like the last paragraph is. This 46, paragraph number 46 is the quotation from another decision.
No, it is missing it. I think.
No,
it is
yes,
missing it.
It was also missing.
It is my. Think it could anywhere else.
Yes, Mr. Barua, what are the decisions you were relying upon?
Only one decision.
One decision.
One decision.
Okay.
I rely on para 10 and 11.
I think it's 10 counts.
Para 10 and 11, my lord. I am relying. Regarding principles required for proving the validity and execution of the will. As per section 63, my lord. And all the principles required for that, my lord, has been fulfilled, my lord, in this case, my lord. The trial court rejected my application only on 3 grounds, my lord. First, my lord, the evidence of the scribe who typed the will has not been adduced. And second ground is the wife of the testator did not sign the will. And the third ground is the attesting witnesses did not inform the close relatives of the testator regarding existence of the will, my lord. On these 3 grounds, the learned trial court arrived at a decision that the execution of the will has not been proved, my lord.
Last ground is?
Last ground is, my lord, the attesting witnesses did not inform the close relatives of the testator regarding existence of the will, my lord. Mainly on 3 grounds, the trial court has come to a conclusion that the execution of the will has not been proved. In my lord, paragraph 7, 8, 9 of the influence judgment. These 3 grounds are narrated, my lord. Paragraph number 7, 8, and 9 of the influence judgment. Page 30.
That's. আমার এই ইনভেস্টার করে দেওয়া হচ্ছে একটা কেস ছিলেন বিডি থেকে ফেল করেছিল আর কলকাতার সিনেমার পক্ষে বাগানিয়া নাম আছে Yes.
My lord. That is para 46, the execution of the will in secrecy. Page number 18, my lord. Page number 18. Para 46, in the middle portion, execution of the will in secrecy without informing the other legal heirs and without expression for such an act was considered as another unexplained suspicious circumstance. Got it, my lord? Execution of the will in secrecy. So, yes, 20, para 51. The will is surrounded by suspicious circumstances. The will is surrounded by suspicious circumstances which remain unexplained, and the possibility of the will was not duly executed by the deceased after understanding the content. It is confirmed. So, since if Pabandar has failed to probe, to remove all suspicion, it is a burden of the Pabandar to, it is a conscience of the court. Conscience of the court, Pabandar should remove the all suspension, suspicious circumstances. The court will is genuine or authenticity of the will has been proved. But here in the case, my lord, Pabandar has failed to prove the authenticity and execution of the will. That's why the trial court made order that the Pabandar has failed to prove the will. Pabandar has failed to prove the will. Or it is. My lord, on that is on Tuesday, Friday. Yes, may adjourn for today, my lord. Day after. Because I will make it time. It is easier. It will be easier for the school.
Heard Mr. Borua, learned counsel for the appellant. Mr. Talukdar, learned counsel for the respondent. List the matter on Thursday for further consideration.
Standing item 2.
May I please, Your Lordship? May I please, Your Lordship? So this is the review petition. What happened, my lord, that earlier occasion the petitioner approached this court, my lord, by filing a writ petition number 2651/2025, my lord, that was decided on 11/9/2025. What happened, my lord, at the time of the pendency of this case, my lord, kindly turn to page 29. Page 29, Annex 7, my lord. The respondent authority submitted vacancy status of Polytechnics of Assam to be filled up through a direct recruitment as on 1/9/2025. As per this status report, my lord, there is no any civil, the post of the assistant professor in the Department of Civil Engineering in the Polytechnics of Assam, my lord. And accordingly, my lord, that my PR was not considered and accordingly dismissed my petition, my lord. But my lord, that dismissal order, lordship will find at page 30 and 11 portion, para 10, my lord. More particularly, para 10 and 6, my lord. 6 and 10, my lord. At page 34, para 6. I'm reading, my lord. Mr. Borua, learned counsel for the petitioner's further submits that the respondent authorities have filed their affidavit in opposition and pursuant to order dated 27/8/2025. Mr. Das, learned standing counsel for the respondent authorities, has obtained instruction regarding the vacant post and submitted a copy showing vacancy status in Polytechnics of Assam, so and so, which shows that no posts under the civil engineering department are being vacant, and as such, the pair of the petitioners in WBC number so and so could not be considered due to want of vacancy in the civil engineering department, as both the petitioners in the said petition belong to civil engineering branches and industrial so and so, and as such their pair cannot be favorably considered by this court. And accordingly, by paragraph 10, my lord, my pair, our petition was dismissed, my lord. And then what happened, my lord, this order was passed on 11/9/2025, my lord. Thereafter, my lord, on 18/12/2025, petitioner submitted an application under the provisions of Right to Information Act. That application, lordship will find at page 38. There is a question is that, my lord, question number 1, how many sanctioned lecture posts lay vacant in the Polytechnics of Assam in Civil Engineering Department? In response to this, my lord, Annex 10, my lord, at page 40, my lord, they have said one post is laying vacant. My lord, now after that, my lord, we have approached this honorable court by filing a writ petition. My lord, lordship will find that order at page 41.
And at the time of the consideration of this writ petition, my lord, lordship has observed that at page 42, last paragraph, my lord. Page 42, last paragraph. It is noticed that if the pair of the petitioner for passing such a direction is to be accepted, it would probably amount to reviewing the earlier order of this court through this writ petition. The same may be considered same in my considered view would not be permissible. Mr. Bura, learned counsel submit that he may be allowed to withdraw the writ with liberty to file the appropriate application. In view of the above, the writ petition stand disposed of with withdrawn with the liberty to file the appropriate application. And accordingly, my lord, I approach your lordship by filing this review petition. Now the question is that, my lord, let him take the instruction whether this vacant post was at the time of the vacancy status submitted by them at the time of pendency of the writ petition, earlier writ petition, the 1/9/2025. If that was vacant at that time, I have a case. Otherwise, if it is vacant later on after passing the lordship order, that is 11/9/2025, then I have no case, my lord. That's why, my lord, let them take the instruction of when the vacancy came to the light, my lord, after passing the order or at the time of the passing the order. This is my single submission, my lord.
Pardon?
Let them take the instruction, my lord, that whether at the time of the passing this order, as per their instruction, my lord, there is no vacant post. As per the Right to Information Act answer, there is a one post was laying vacant. If the post was laying,
Where is the reply of the RTI?
that is lordship will find at page 40, annexure 10. Point number one post. My question was, lordship will find at page 38. How many sanctioned lecture posts laying vacant in polytechnics of Assam in civil engineering department? They answered one post at page 40. But earlier occasion, there is instruction that there is no post.
Where is the earlier?
That is at annexure 7, lordship, page 29.
But on 1/9/2025.
This information was updated 1/9/2025.
Yes, madam.
That vacancy was as on 1/9/2025.
No
On that
vacancy.
day, there was no
No vacancy.
vacancy, and the order was passed by this court on.
That is the data I met for before the report. There is, my lord, he filed one RTI application in the month of December. After passing out his order. And the reply came in the month of January. 1st of January 2026. As on that day, January 2026, RTI reply says that there is a vacancy. But that I have spoken to the authority, they are saying that this vacancy is after passing of the judgment. Madam.
Passing of the judgment.
Madam.
Let them clarify.
Because somebody has retired.
Who is retired, when retired, that will be clarified, my lord. And if it is so, my lord, I have no case, my lord.
No. This review petition is filed by you. It is your burden to establish that on that very date the vacancy was there.
Madam, I am on the reply made by the authority in the RTI application, my lord. As per in the RTI application, that is not mentioned in that when the vacancy.
So
came
then
to-
you could have obtained subsequent information of when the vacancy arose.
Madam.
Where is the question of directing him to obtain instruction here? This is not a writ petition.
Yes, my lord, this is a review.
This is a review
This
petition.
review petition, my lord, that is correct, my lord, but in the RTI reply, my lord, that is totally.
We cannot conduct a proceeding like a writ petition here. It is burden is entirely upon you.
That is true, my lord, that is
Then-
up to me, my lord, but as per this RTI report, my lord, we approached this court earlier occasion by filing a writ petition.
You
That-
go to that court then.
Yes, my lord, that will be better.
You go to that court.
I-
This court cannot conduct this proceeding as a writ proceeding. This is a review petition.
Yes, my lord, that is true, my lord.
Then
Then I have no case, my lord, then.
Mr. Das, are you sure that it was erased
I
and
have-
subsequently?
I have spoken to the authority, my lord. They are saying that although I don't have any written communication, but they are saying that vacancy is arose after the passing of the judgment because somebody has retired, my lord. That's why this vacancy is showing in the RTI reply in the month of January. And my lord, before that, my lord, as my lord has rightly pointed out, he must ascertain whether that vacancy is was available in that period.
Mm.
Well, that at the time of passing of judgment.
Yes.
Then only because this will not come under the purview of review, my lord. If he can certain whether if that vacancy was there at the time of passing of the judgment.
Yes, therefore there is a requirement of reviewing the order.
My lord, then only.
For this relevant document, you file RTI. This is not a writ petition.
Yes.
Heard Mr. Barua, learned counsel for the petitioner, Mr. S. Das, learned standing counsel for the Higher Education Department. List the matter after vacation.
Yes.
So as to enable Mr. Barua to obtain instruction in respect, no, Mr. Barua to obtain requisite information in respect of the date of the vacancy as mentioned in the annexure 10 at point number 1.
Number 7. For you, item 7. I just told my fellow friend, I'm looking at the LCR, in fact, I do not. Let it be taken Thursday, right? My learned friend was here just now. But I'll just look into the LCR, I have not gone through the LCR.
Okay, Thursday.
Thursday.
As agreed by learned advocates of both the parties, release the matter on Thursday.
Item 8.
May it please your lordship, my senior is in another court. She is coming, so kindly pass over the matter for the time being. Like,
Item 10.
due to personal difficulty of contending counsel DRT, my lords will kindly adjourn the matter for today.
This is of 2019 matter. Heard. Ms. Chakraborty, learned senior standing counsel.
Special Senior Railway Council.
Special senior
Railway
railway council. For the appellant and Ms. Bihani appearing on behalf of Mr.
Respondent.
For the respondent, Ms. Bihani submits that conducting counsel has some personal difficulties today, and she press for listing the matter after
My lords, any date.
Minute after vacation minute.
after vacation. Okay.
Minute, there is another, one appeal is filed by me, another appeal is filed by them, minute, cross appeal.
Mm.
Item number 10.
Mm.
Again, they come same judgment.
Okay. Both the matter then we'll hear together.
Much of it.
Same order.
Date is not fixed, my lord. Date.
Date covered.
So on vacation, any date.
30.
30. Bless you.
Item 12.
Your lordship, my senior is engaged in another court, so
Mm. You are not ready to argue the matter.
your lordship, I would like to take us for some time.
Sometime
Yes, your lordship.
today or
Yes, today itself.
okay.
May it be pleased, your lordship.
Yes.
Lordship, as per the last order, the respondent counsel for respondent number 1 has prayed for some time to seek instruction as to whether at the time of passing the impugned order, whether there was any special or general order enabling a member technical to sit singly and take up the claim cases under section 4 of the Railway Claims Tribunal Act. Lordship, it's a order passing by member technical, single member of the Railway Claims Tribunal.
No, but today the council is absent.
Lordship, a short date may be given.
Short date. Third Miss
M. Kolita.
M. Colita, learned counsel for the appellant, none appears for the respondent on call. This is the matter. Okay,
23rd June.
23rd of June.
Oblige your lordship.
Nice.
13.
13 already passed. Order passed. The other side is absent.
Okay.
But I have come here. Yes, Lordship, I have done through that decision. So the basic principle of that judgment is that the say 100% disability may not affect the earning capacity of 100%. And that will depend on the medical documents and the evidence before the tribunal and nature of injury sustained by the victim. But here in this case, it is a case of Lordship brain injury. So it is not a case of that injury is in the limb, particular limb. Suppose a hand is injured, it may not affect the earning source of the entire body or the 100% earning capacity of the individual. That will depend on the nature of the work. And here, Lordship, the victim, she was serving in a laboratory, and after the incident, she has already been removed because she is not in a position. And the laboratory authority has appeared before the tribunal and produced evidence. And regarding Lordship removal, etc., everything has been Lordship narrated before the tribunal, and evidence is there to that effect. And here, Lordship, the present situation, this is the case, Lordship, of 2008. She was produced, she was appeared before the tribunal in the year 2016. After 10 years also, she was at that position, Lordship, that time, not in a position to say a single word. That's why her cross-examination was declined by the tribunal. Well, let's so far the
According to me, the absolute disability of the victim is 100%.
yes, Lordship, practically it's 100%. If your Lordship wants to produce before this court also, Lordship, I can produce her because her condition is very serious till date, Lordship. She has not even possible to take a glass of water.
Yes, Mr. Dr. any reply?
Your Lordship, no reply regarding that, but according to the evidence of the doctor, the disability was 90%. So 100% only my learned friend is claiming.
And the
Only
first-
one thing, Your Lordship, the statutory amount may be refunded. Statutory amount of 25,000. Yes, Your Lordship, only that. Much obliged.
and then one judgment, Lordship, I want to, Lordship. Kadol judgment, Lordship, regarding disability and the award given in pain and suffering, etc. My question, question on that, Lordship. Your Lordship, I have given the paragraph, Lordship. Yes, Lordship. Lordship.
Much obliged.
May please, your lordship. Lordship, in this case, I am praying an little accommodation, lordship. If your lordship allows me to do this matter at 2 p.m. or Thursday, lordship. In the meantime, lordship. So lordship, in that case, Thursday, lordship, this is a old pending case, 2013. And in the meantime, I may be. Yes, lordship. And in the meantime, your lordship may allow me to go through the LCR also. And lordship, in the cause list, the name of other respondents are shown, but on the last occasion also, no one appeared, and today also there. I am for the appellant, lordship. Respondent Standing Council Elementary Education, and one R Chakraborty is there for respondent number 8. But on last occasion also, they did not appear, lordship. R Chakraborty. Name of Mr. G.C. Fukon, M. Dev, U.J. Saikia. They are standing counsel from Education Department, lordship. Lordship, Thursday at 2 p.m. if your lordship allows me. And so that this regular first appeal can be disposed of on Thursday, lordship. So that lordship, this regular first appeal can be disposed of on Thursday, lordship, at 2 p.m. lordship. Lordship. I'm deeply obliged, lordship.
Lordship, may I pray some little accommodation, Lordship? My senior will argue this matter, Mr. T.J. Mohanto, Lordship. He is on legs in some other court, Lordship. See, possible on 18, Lordship. 18 of June.
18, my lord, appellant has prayed for time for 18. But no objection.
Or at 2, if possible, today at 2, Lordship.
List over, lordship.
Then on 18, Lordship. Yes, Lordship. I think he will be free at 2, Lordship. He's on legs. Then on 18, Lordship. 18, Lordship. Obliged.
Covered.